All right, I
And
can.
we're live.
All right, hi, this is Curt Verone,
And Brad Pinsky.
and we're here for another edition, a special edition, but another edition of Fire Law Roundup for May 12th of 2025. Brad, go ahead.
Well, we can't not start with a huge congratulations and shout out to you for graduating with the master's in forensic psychology. And most people are saying, why the heck would Curt Verone, a lawyer, ever want to do that degree? And not to answer for you, but I think you should talk about it because the interplay between law and psychology that you have realized has been immensely helpful. Toxic individuals, why people bring lawsuits. And the last thing I'll say to you is, and really how you address people that you are going to be able to the toxic people, or to be able to how to deal with them, documentary, etc. Understanding them is giving you such an amazing insight to how we do things.
Yeah, it's a journey, a 40-year journey or so since I became a lawyer and started recognizing certain profiles of people, of clients, clients of my dad's, clients of my own, people that would contact me with cases. Some of the things that you and I learn at our continuing legal ed, like when a person does A, B, and C, you do not want to represent them. When someone approaches you like this, you don't want to approach them. Well, it all connects now. Why? Now, the people who were saying that learned it from experience. They didn't have any data to back it up, but they knew this type of client is the type of client that's going to sue you. Why? Well, now we know, and we can diagnose them, and we can't treat them. I mean, psychologists can treat them. As attorneys, we can't treat them, but there's things that we can do. So there's an awful lot of intersections and interconnections. Also, just doing the investigations, the discipline investigations, and other types of sexual harassment investigations, and trying to figure out, who's telling the truth, who is weaponizing the discipline system to get somebody in trouble, and all of that. So there's a close intersection with forensic psychology and what we do as firefighters and attorneys. So,
And
so
really all of HR, personnel management, discipline, counseling, all that seems to fit everything you've told me. Just understanding who people are to almost predict the future of what they're going to try to do to you.
well, if they fit that pattern, the I don't know what you want to call them, the games they play, the patterns they execute are repetitive. And sad to say, they've been repetitive since they was visible in their personality since they were 5 years old. So
Well,
this
I
is
would
not going to be anything new. They've run this same, it's not fair to call it a scam, but they've run this routine with their parents. They've run it with their school teachers. They've run it with prior employers. Now they're working for us on the fire department, and they're running
right,
the
right.
same deal.
And as
So,
lawyers, we've all had those people. Unfortunately, I never recognize them until you're looking back 5 years. They filed this complaint, did this, did that, you did this, they reciprocated with that.
and
It's
nothing is their fault, and they
right.
come to you, help me, help me, help me. I got this, I got that. They're picking on me, they're doing this, they're doing that. And then certain things we can help them with, and then you're their hero. But some things you just can't. You can't get it through. And then now you're the person that they're going to go to another attorney about, or the bar association about, and complain about because that's ingrained in their personality. So, but
Agreed.
he who
Okay,
has,
well, congratulations on that, and we look
I
forward
appreciate it.
to
Thank you.
the continuing comments from just a vastly opened up viewpoint into every one of the cases and types of people. Let's start with a lawsuit that's been filed. Kudos to whoever's filed this, the attorney. There was a line of duty death caused by an explosion from propane, and $100 million suit has been filed. That's probably too low in my opinion. But basically, the firefighters responded to a report of a gas that was allegedly said, hey, it's not an emergency, nothing's urgent. But the employees reportedly have fitted or filled 125 gallons of propane into cylinders that were faulty, knowingly known faulty. So they created a dangerous condition. The reason this will be a very interesting case, and I have this question, I will give you my thoughts, is if here there is a firefighter rule, meaning that firefighters cannot sue if they're injured in the line of duty. Now, some states have the exception, and the exception is important to talk about. I don't know, this isn't a universal exception, but typically what they say is if the injury was caused, these statutes, if the injury was caused by the type of environment you had or to other negligence caused by the property owner, which was not the fire itself. And this is where this is hard. So let me give you an example. We covered a case where firefighters went to a fire and they went into the house. They fell through the staircase because the homeowner had removed the banister. Now, there would be no liability for the fire going to the fire. That's the normal risks. But when they created a property danger, like no banister on a staircase that we would have expected would be there and we fall, then there's negligence. Here, the reason I think this is exceedingly interesting, and I know, of course, we'll keep following this, is, although this will probably settle, but the question of, okay, what caused the explosion was your negligence, right? It wasn't like, okay, there was an explosion and somebody slipped on ice that you should have cleared before they got there. This was, they were injured by what was giving off the gas smell, right? These leaking containers, and it was leaking because they filled faulty containers, allegedly. And so is that an exception to the firefighters rule or not? And I think it's a very difficult situation to analyze, and I'm very much looking forward to the answer.
Yeah, I almost think you and I could write a book on the firefighters rule because and each state could almost be its own chapter because it seems like every state has a slightly different wrinkle when it comes to the firefighters rule. And some states are anti-plaintiff and they just say firefighters can't sue at all. And then there's other states that say, no, we've abolished the firefighter rule. And then there's a whole bunch of others. Some say that the firefighters rule arose out of property law, and that whole invitee and
Yes.
you know all of that. But they say that because it arose out of property law, it only applies to suits against the property owner, not against the third party. Okay. So I think that's an interesting wrinkle. There's also most states that recognize the firefighters rule have exceptions for things that go beyond negligence, such as gross negligence. And in this case, they've at least the prosecutors have charged the guy, I guess the head person from the gas company that was on the scene and telling the firefighters you can leave, there's no emergency. They've charged him with manslaughter. And that would, if assuming that he is convicted of that, or even of a lesser but still criminal negligence based charge, that's going to be greater than negligence. Criminal negligence is greater than ordinary negligence. So I think there could be a couple of exceptions here in the firefighters rule. And again, I'm not up on Virginia's version of the firefighter rule, and hopefully there is some compensation. But interesting, the property owners are also plaintiffs in the same case. And I don't know how you do that.
Right.
Think about the ethics there because they are potential defendants, right?
Oh, yeah. Oh,
And
of course. Dangerous
but
condition maintained on a property you own, of course.
yeah. So, but at the same time, I think they probably said, well, you know what? The real culprit here is not the property owner, and but it'll be interesting to see some of the defenses that the insurance company or the utilities insurance company is going to come up with.
It's very interesting because I just referred a case. I won't give any more details where it is, but I just referred a case where a pool company, like a swimming pool, took all their contaminated, chlorine filled 50 gallon drums, or whatever the big massive drums are, and like 40 of them, threw them in a waste container. Now they're obviously easy to see. A waste hauler took them away, took them to a dump. They get a call for a smell, and somebody started inhaling that gas because they didn't know or expect it to be in there. They were in what they thought was a safe zone. Nobody knew they would be in there. Certainly, they shouldn't have been, disposed of that way. And now a 40-year-old has COPD.
Oh
So a
boy.
big, big lawsuit.
Hmm.
I simply didn't have the time for it. But this, it's the exact same question. The negligence, what caused the injury, is how does that play? It is exactly what caused the injury, what caused the fire, what caused the need to call somebody. So I don't know how this plays out in the firefighters rule, but you're right, it's very state specific. And
Was
I hope.
another while we're on the subject, it's an interesting issue. You were kind of talking about when your negligence causes the injury, and that's sort of the causation part of the firefighters rule, because some states look at causation and they say, okay, was the negligent act the causing of the fire? Firefighter Pinsky advanced the hand line into the building. The floor had burned out and he's injured. Okay,
Right.
well, that happens. There's nothing negligent on your end. There's nothing negligent on the homeowner's end about that. But there was negligence in causing the fire. So the negligence ended up resulting in and it's
Again, I don't think
foreseeable the
that
fire.
falls within the exception. I think you can't sue.
Exactly. That's really, I think, one of the scenarios where the firefighters rule makes some sense. Okay.
Right.
But some states follow that causation rule and they say, like you said, where the stairs have been removed, it's not the causing of the fire that is the negligent act, it's the removal of the stairs and not putting warning signs up that is what allows an exception to the firefighters rule. Look, honestly, we could write a book. It'd probably have
Yeah.
about 15 chapters in it because there's a bunch of different ways that states have handled that.
But everyone should know if this is a good or a bad holding for the fire department, and I'm a little fearful, but again, haven't read the statute. Don't be encouraged or discouraged because it's very state specific, and there are many states who just say firefighters still can't sue at all.
Okay.
Okay, let's go. Now we're going to go. This is not such a new case. In fact, I feel like we've seen this exact type of thing. We're going to go to Louisiana, where the Fourth Circuit Court of Appeals, a federal court, affirmed a workers' compensation ruling in favor of the firefighter's family. So what happened is the firefighter died from acute respiratory distress syndrome. He was attending out-of-state training. Now, he was hospitalized for acute respiratory distress and multifocal pneumonia, but the cause of death was listed about the same, secondary to influenza. This is the problem. So under these presumed cancer laws, it all, just like we said on the firefighters rule, it comes down to how the law is written. And there's so many versions of this. This one in Louisiana is very broad for the firefighters' protection. And basically what not basically, what the court holds is it doesn't matter how he got it. He was and very important. The one question which I would have been biting my nails to ask if I was his attorney, I'd be saying, are you telling me, Mr. Expert, you can 100% rule out firefighting as a cause? And the answer that came here clearly is no. The court says they could not rule out firefighting as a cause. So absent 100% proof and a conclusion that, this was not caused by the fire service, they had to award it to him. And so
Yeah,
must have
there's really two parts to that. One part is that they can't prove that he didn't contract the influenza when he was on the job. So
point.
that's sort of problem number one. Problem number two is a little bit more complicated. They get into it a little bit in the decision, is that there are things that we can be exposed to as firefighters that can reduce our immune system and make us more susceptible, even momentary. You go to a fire, you know what you feel like afterwards, you're kind of knocked down, and then you get an influenza virus that your body would have been able to ward off, but you're still sort of immunosuppressed from the battle and the smoke and everything else. So there's really a couple of different things. But the bottom line is the court said no. The city did not rebut the presumption that a respiratory condition wasn't related to the job. So now, departments that don't have that presumption, this is an example where you're going to lose. You know, even if it was cancer, if you don't have that presumption, there's no way, because the flip side of the question you just asked is the one that's going to be asked by the
You got to
city.
prove it, right?
And right, you can't do it.
So, again, everyone should be very specific to read their statute, but, the burden of proof is the big issue here, right? Who has the burden to prove how it was caused or how it wasn't caused? And a lot of states do have some cruddy laws, or they're very limited to the type of cancer, but they come up with these laws based on financial resources available, right? They say, well, if we expand it to any firefighter who's sick for any reason, within X years of the job, like New York says for 5 years, and I hate this, but it's a financial thing. For volunteer firefighters, 5 years after you leave the department, you're covered. But after 5 years, you're not. Well, wait a minute. I mean, but it makes no logical sense, medical sense, but it's just a financial issue.
And I've seen some states that have that. They'll maybe start like at 5 or 6, but then for each year or each 5-year period, they'll stack onto that to take into account someone like yourself or I. You got 30, 40, 50 years in it. That's not the same as somebody who's only been a firefighter for 5 years. So.
And that's what bothers me about these, but I get it. It's financial. But kudos to Louisiana, who has, obviously a very firefighter friendly rule. Okay, we're going to go to Washington State. Wow. This was this was not insignificant. So we have a Washington State firefighter. You just don't do these things. We have a Washington State firefighter. She was terminated in August of 23. She was terminated after she filed a gender discrimination and retaliation claim. You try not to fire these people. I'm not saying they've got immunity. If you can try not to fire them or retaliate against them. And anyway, she just got paid $540,000 and reinstated. But there's nothing more complicated. She alleges, she was discriminated, alleges certain retaliation, and now she's fired. Now, the problem is, let's go back to your toxic person. I'm not talking about her generally, right? What do you do? I want to speak to the fire chiefs, the HR people. What do you do when, okay, you have a claim and now this person's acting out and you have different reasons to fire them? Let's call them valid reasons. My answer is, listen, you got to fire them or discipline them, but you better have good documentation, 100 ways to Sunday. You better have a good investigation. You better have an airtight case that this person needed to be terminated or disciplined, and apparently not here.
The psychology that I study, we had a class really that spent most of the semester on bias and decision making. And what can happen here is in the back of everyone's mind, back where the mammalian part of the brain, you have this person's not a favored person in the department, and the decision making is affected by that. And they decide, oh yeah, that's enough. We're going to fire her. And perhaps maybe someone who's not disfavored has had a similar situation and they didn't fire that person. They found an excuse not to fire them. So you've got to look both in your rearview mirror about what you've done in the past about similar types of things. And you got to be looking down the road again. What are we going to do with the next one? Is this how we're going to handle it to be consistent? And it can be a challenge. And the safest bet is when someone's certainly filed a claim, but particularly when they've already filed a lawsuit. Good God, what are you thinking?
And I got to tell you, some people think, okay, we have somebody who filed a claim, we investigated and it was proven not founded. It was unfounded, right? We did our good investigation. And so now we're free to fire the person and retaliate. Yeah. No, you're not. The laws protect somebody. Even if they filed a claim and it was deemed unfounded, you still can't retaliate for that. Now, I'm not saying they did or didn't, right? That's not the point. This is a good lesson for everybody. If you are going to discipline somebody for something else unrelated to their complaint, you better have an airtight case to show it was not retaliation. And because, as everything you've been talking about from your education here with the masters, is that, people will use these suits as a way to avoid being terminated for something they're already in line for being terminated for, right? That's how they try to protect themselves. Well, look, no reason to worry and not keep on your course of discipline, et cetera, if you have the airtight investigation and discipline process.
Right.
But if you're just
But
doing it half, you know.
yeah, and so often one of the terms we learn it's a guilt presumed investigation.
Yeah.
Okay, think about that. And that's a
Think about
problem. That's really something in law enforcement where a guilt presumed investigation, where it's targeted. It's like I use the metaphor, the dog chasing a rabbit, but you've got like laser lock on that person, and you're just looking for the things that are going to align so you can fire them. And that can be a problem because we're not being consistent with how we've treated other people backwards and forwards. So
And the
it's a
time, I got to say this, I think, I don't know if it was your comment or maybe Chip made the comment, but the time to start good documentation is not after they file their first complaint, right? Well, they filed the complaint, so we start documenting everything. Okay, that is retaliation. And you may be just improving your praxis, but that's what I normally see happening, right? And I've given that advice accidentally, being like, okay, well, if we think they're doing something else, let's document everything. And then I didn't realize that's the first time they start documenting everything, and it just looks bad. So I hope everybody is documenting everybody, your top performers, your lowest performers, everybody. They do something wrong, right? You investigate without bias or belief, and then you treat everybody the same.
I don't think we can emphasize how critical retaliation is in the general sense of HR. Because, like you said, somebody can lose whether it's gender discrimination, sexual harassment, race discrimination, they can flat out lose that. And in most states, the sexual harassment bar is very high. It's hard. It's got to be severe or pervasive. There's a couple
Not
of
in New
states
York.
that aren't, but right, but it's got to be severe or pervasive. So often they'll say something and the judge will say, well, that was inappropriate, but it was
Not
not
severe enough.
severe and it's not pervasive, therefore you lose on sexual harassment. But let's talk about them disciplining you. Let's talk about them firing you. Let's talk
Yep.
about them alienating you in the firehouse.
Yep.
That's retaliation. They're going to win on retaliation.
And the
So,
general mentality, I hate to generalize, but the mentality of some people, some firefighters is, haha, you lost, whether it's on investigation or court, and now we're going to free to come after you.
oh
No,
yeah.
you're not. That person is more protected than they were, right? But that's why they're
Oh
doing
man.
this. They're doing
You
this
gotta
to
love them.
vote you.
You gotta love them. But
Oh. All
Jesus.
right, well, let's go to Columbia-Richland County. Where the heck is, oh, South Carolina. So
No,
we're going
it's
to go to South.
Columbia. It's Columbia Fire Department, but it's
Oh,
Columbia, and they've merged now with Richland County. So it's
a
a
good department.
pretty good size, big department. Yeah.
Yeah, big and a good department. But and anyway, we have a widow of a South Carolina firefighter who was killed while operating at a structure. This will tie into almost our last conversation about the firefighter's role, though it's a little different. She's now filed a wrongful death suit, now adding in the city, right, and Richland. And the problem is basically what she's suing for. There was a collapse, the firefighter's killed, and basically what she's suing for is this building you knew was not safe. It was built pre a code which required fire separations, and you should have pre-planned their building. And I read this as a failure to pre-plan, and you shouldn't have gone in, or you should have pre-planned. You should have known it was dangerous, and they're going to lose. I hate to say it, but my general feeling, armchair, a little armchair here, but my general feeling is that's too high of a burden to place on a fire department, that you should have pre-planned.
Yeah, I think we're talking about a good sized department. I'm not sure if they meet the technical definition of a metro department, but they're a busy fire department. They have fires all the time. I'm not sure about Irmo. I know it's a suburb of Columbia, so they come in on automatic aid. At least according to the complaint, it was automatic aid. And so, there's always a level of inefficient, in my opinion, my experience, level of inefficiency that creeps in, especially with command and control, accountability, and communications. And so, in addition to maybe the tactical and strategic decision making, um, one of the issues that may play a role in here, and you can kind of go through the complaint and tease out some of the things they're alleging. But I think one of the things is that it was not communicated to the mutual aid people that people had already reported the floor was sagging.
Yeah,
And
that one's a little better.
right, but I think one of the questions is going to be, what happens on mutual aid. I don't know if they're sharing radio channels, and if they were on the channel when it was said, they weren't on the channel when it was said. They were directed to go in. I know one of the problems we have with mutual aid is very often the mutual aid feels like they can just go do whatever they want, and they're not part of the plan, and they just go in on their own without the incident commander knowing. And
It
so
happens.
I think
Yeah.
there's a lot, but there was some state OSHA citations issued to the department. So I know some of the chiefs down in Columbia, the line chiefs, and they're good ICs, so the allegations kind of strike me as a little bit off from the people that I know that are on there. And I don't know any of the folks that were involved in this incident, but it goes to the importance of having accountability, having good incident command, having command and control, managing the radio communications effectively, which are, you know, when you're a firefighter, you just assume that all this stuff gets taken care of. But when you're a chief, you realize, oh my God, this is
Right.
this is overwhelming sometimes at the command post.
And
So,
this is going to be a good example, perhaps, if this continues. The public doesn't understand what's acceptable. I'm going to give you another example of what I mean, but the public doesn't understand what acceptable information or acceptable circumstances are on the fire ground. For example,
mhm,
let's say the statement was made, hey, we're having sagging ceiling, or the floor feels soft, or the roof feels soft, as we're sounding the roof, and whatever it is, that's a piece of information which is put together with the smoke and the fire load and the age of the building and the type of construction and whatever else is happening on scene. It is not the be all and end all. Whereas one person might say, oh my God, you've got a sagging whatever, it's going to collapse. Wait a minute. Maybe this is a legacy constructed building. Maybe we know that it's whatever. They're all true 2x10s, true by 8 rafters, not trusses.
mhm.
Maybe we know a lot of things, right? It's just one piece of the information. But I think people, the jury, the public hears something and says, oh, you should have known. But
Mhm.
it's never that one factor, right? It's multiple factors that lead to building collapse. How much time and type of construction and blah, blah, blah. So
But then, how do you brief everybody that's coming in? Okay, so you have a fire starts at 1 o'clock in the morning, okay?
right,
And then 1:10, you bang a second alarm, and then 1:15, you get the third alarm. Well, the people coming on the third alarm didn't hear a radio communication that happened between 1 and 1:15.
right,
And and especially mutual aid coming in where that might be on a different channel and so on. So somebody's saying at 1:08 we've got a sagging floor. Well, the guy
yeah,
who hasn't been dispatched yet might not have heard that.
right.
And so how do you brief everyone at the staging area? Okay, well now we got to spend like they do in Wildland. All right, so we're going to give you a 20-minute briefing before you go to
Right,
work. No, we don't do
right,
that.
right.
So again, it's the challenge of communicating all that information effectively to the folks that need to know it. And
Yeah, the IC needs to know, and not too many other people do. But the IC needs the information. I mean, I'm not going to lecture to the intelligent
yeah,
firefighters on here. The IC needs the information, but you're right. The firefighters need to know only what they need to know.
yeah,
Um, but anyway, so I think this is going to be a tough case. I foresee defenses. Look, I think there's a lot of defenses. It's not their employer, maybe, presumably, right? So you
right.
can't sue your employer, but you can sue your mutual aid.
Right.
I wonder though, and
Who might have sovereign immunity.
yeah, exactly. Right. Most likely here. And especially for a discretionary decision,
Yeah.
because it is a discretionary decision. And what else was going on? And what was the risk? Was the building evacuated? Do we think there are people there? I mean, there's so much that goes into discretion. I,
Yeah.
I worry what a
Oh,
jury understands, but that's the
and
good
who
part
made
about
the
good
decision
lawyering.
to send them in? I think that's another important. If the incident commander said, "I want you to go in," all right, well, it's on the incident commander. But
Yeah.
if they said, "All right, you've got side delta," and guys are going, "Oh, well, let's. I think we can get it from here," and so there's a lot of factual questions there.
People never understand how dynamic the fire ground is, right? And in business, it's funny. A lot of us have been doing lectures to corporations, non-firematic corporations, and I've asked them like, why do you want somebody to lecture on, who lectures to the fire world? And among a million other reasons, the dynamic evolutions, how you work together that every situation is a crisis situation. How do you work together and keep reevaluating and adjusting and working together and updating and community? I mean, I think corporations find that very interesting because it's not the real world. It's not the normal world. It's our real world. Okay, well, let's end up here in Leduc, where we have a class action which is bigger than God. I mean, this is just a massive, massive settlement. So what happens is, and this I think you would call not systemic racism, systemic sexism, and it is a system here. There was a class action lawsuit filed in 22, started by two former female firefighters, and is now spread well beyond the fire department. And they awarded, get this, they awarded $9.5 million to be spread over a number of the plaintiffs and victims over a 21-year period.
Well, Brad, we gotta talk about this because we covered this when the verdict when the settlement was initially announced back in whatever it was 2023 or whenever they settled. It was one of our first cases we talked about. And this is both Canada and the UK are going crazy with political correct adjustments to the fire
21
service that they
years.
go. Well, what they're saying, what sounded like a good deal, and I think this is the problem. It sounded we're going to come clean with all this stuff that's been happening. All right. So now what they said was it's not just going to be these two women. These two women filed the lawsuit. They had been harassed. Apparently, they had been harassed. There was enough evidence that they had been harassed that the city rolled over and said, we're going to enter a settlement, not just for these two women, but we're going to extend it to anyone and we're going to get them. Let me just read it here. Depending on how badly you were harassed, you're going to get between 10,000 and 285,000. Okay. And then we're not just going to limit it to the certain period of time. We're going to open it up to this, whatever, 19-year period, 21-year period. And lo and behold, people came out of the woodwork. It was the total number of plaintiffs, 155.
Yeah. Yeah.
And those were the ones that were approved. I don't know how many women alleged. Now, these were not all firefighters,
Right.
obviously.
This is
But
outside the fire department
anybody,
as well.
yeah, anybody who worked for the city over that period of time is going to get a check if they can allege that they were harassed or jump through the hoops. And so I think here's my point. I don't think the people who originally agreed to this settlement back in 2023 had any idea they were going to saddle the taxpayers. And as evidence of that, they tried to keep it private. They didn't want it publicly
Yeah.
released.
Never
And the
gonna.
Alberta Court of Kings said,
Right.
you're going to have to make this public. People should know. Taxpayers should know. And so I think it was a mistake back whenever it was a politically correct mistake back in 2023 to open it up the way that they did. And I'm not saying these women weren't harassed, the two firefighters.
We're not saying they
were
weren't deserving,
okay.
but
But they
everyone
opened the
else.
floodgates out of it seems to me an act of political correctness. And now they're trying to hide it from the taxpayers that they cost the taxpayers 9.5 million. And
Yeah.
the taxpayers ought to hold the elected officials who were responsible for that settlement accountable for it.
Right. Look, and we're not excusing, the underlying actions, right? The harassment, discrimination, whatever. But to go back 21 years, I look, I'm not a fan of reparations, whether it's to black, whether it's to Jews, whether it's, and I'm Jewish, so I'm just, right? I'm not a fan of reparations. What happened was horrible at the time. It should have been redressed at the time. But to go back umpteen years later, when you have no witnesses, no defendants, no insurance coverage, there wouldn't be anyway, but no way to defend yourself. It's just a money grab. Now maybe they had people actually screen and they had proof of whatever. I don't know that how they got, validated, but Jesus, kudos to the two women who came forward because that's not easy, but
Right.
wow, you can't correct history. They can pay for it, I
I
guess.
know it. And, hopefully we're starting to turn the corner a little bit on some of this stuff, but, the politically correct settlements, instead of a just settlement, if someone's been harmed,
Right.
they should be compensated. But to just say, oh, yes, we have been, it aligns with my political views and it's obvious what's been happening. So, well,
Right.
is it obvious? Is it not obvious?
And
And
where do
if
you
it's
think the 9
obvious,
million
you should
comes
be able
from?
to prove it. Why didn't they sue back in 2002, 2003?
Right. Right. And you and I are going to take a lot of crap for this. But that's just our view. There's a reason there's a statute of limitations. And when the states like New York, like California say, okay, well, you can sue going back 100 years, even if the person you allege did something to you is dead, you get to sue now. And by the way, again, there's no insurance coverage because it was umpteen years ago. And this is true with sexual assaults against the children, right? And with like Boy Scouts. Again, I still have 13 cases pending and with lawsuits against Boy Scouts were from the 1960s. How would you like to defend that? And this is the same type of thing. And what does it result in? A $9 million settlement.
Yeah. That they tried to hide from the public.
Yeah. I mean, at
Why
least be
would they,
honest.
if why would they try to hide that from the public?
Right. Yeah.
So
You allow these women 20 years ago to be harmed. Let's assume, right? Well, that's a foregone conclusion because they paid for it. Then you didn't do anything back then to assist them. Now you're going to pay them. Great. And so now you're going to lie to the taxpayers. Come on. Just, you created this situation. Anyway, okay, I don't know what even to say about these people. So,
all
but
right.
kudos to the women who came forward. We very much support you. Seriously.
Yeah.
That's
Okay,
it.
well, I think that's going to wrap it up for another edition of Fire Law Roundup. I will be back in the United States Friday or so. So next week we should be on. Are you're in town next week?
I'm here. I'm in
All right.
town now. I wasn't supposed to be. I was supposed to be in
I know.
Michigan at a meeting, but my plane didn't want to leave apparently, so I never left.
All right. Well, that'll do it for another edition of Fire Law Roundup. If you haven't clicked like or subscribe, please help us out. It helps our algorithm, helps other people find out about what we're doing here and the information we're trying to relay to firefighters. So please help us out by clicking like and subscribe. All right.
And we're just trying to
I'll
make
do
you
it
all
for-
better leaders, right? Better leaders to become more aware of what's out there.
Yeah. That'll do it for another edition of Fire Law Roundup. Brad, we'll